A man walks into his home and allegedly finds an 18-year-old in bed with his wife. What happens next? Police say he brutally stabbed the young man to death and then reportedly put his body in a trash can. The victim had just turned 18 only 3 days before he was found allegedly canoodling with the married woman. That woman was 31 years old. She was also stabbed but survived. I'll walk you through what police say happened. For Law and Crime News, I'm Kennedi Walker. This story brings us to Sequatchie County, Tennessee, where a case of alleged infidelity turned into a brutal crime. 41-year-old Jonathan Belk walked into his home and allegedly found his wife in bed with another man. According to a police report obtained by News Channel 9, he flew into a violent rage, reportedly stabbing the young man to death and injuring his wife, 31-year-old Jada Gholston. Gholston reportedly showed up to the ER bleeding from stab wounds, and police were dispatched to the hospital. Per the report, Gholston told investigators that a man jumped on her boyfriend while they were in bed. That boyfriend was 18-year-old Billy Floyd, a man 13 years younger than her who had just turned 18 only 3 days before the deadly encounter. Deputies rushed to the couple's home where they reportedly found Belk covered in blood. Police say they found the teenager's body in a garbage can. The body was reportedly found in the fetal position. Also, according to police, Belk's biggest worry appeared to be that the deadly attack might ruin his marriage. He allegedly told investigators, "I am worried about my relationship with my wife due to the fact that I offed him." In Floyd's obituary, it says he was known as Lil Bill. It went on to say he enjoyed spending time with his family and friends, hunting and fishing. It's unclear how long he and Gholston were allegedly involved with one another. In Tennessee, the legal age to consent is 18 years old. At the time of his death, Floyd had only been 18 for 72 hours. And joining me to talk more about this story is former prosecutor and current criminal defense attorney Safa Robinson. Safa, thank you so much for coming on today.
Thank you, Kennedi.
So let's just dive right in. How do cases involving crimes of passion, such as infidelity, typically unfold in the legal system?
Oftentimes what happens in cases that have a crime of passion, and in most states there is some sort of legal definition for that, they often play out in the area of murder, yes, but oftentimes what happens is those cases, and part of the defense would be that it was not intentional, it was not premeditated, which is the culpable mental state of most murder charges throughout the states. In a crime of passion, what can often happen is that at a trial or even through negotiations, there can be, a finding of guilt from manslaughter. So with respect to manslaughter, there's that removal, they're removing the culpable mental state of intent. They're removing the culpable mental state of premeditation, if that applies to whatever murder charge that is. With the manslaughter conviction, specifically with the crime of passion, basically the idea or the argument is that the individual was provoked by some sort of event, and as a result of that provocation, they acted in a manner that they may not have normally acted in, but that a reasonable person would act in if they encountered that type of event.
Usually, does the defense argue maybe temporary insanity or anything like that? And how does it affect the outcome of the case?
Well, what will often happen is we would go to prove that this, in fact, either we're going to go with a flat out not guilty, this person didn't do it. The prosecution can't prove it at all. They can't prove intentional. They can't prove premeditated, depending on the state. You also can't prove reckless, which is our manslaughter culpable mental state here in New York. So we negate those things if we can, and if the proof shows that. Otherwise, if we're looking at a murder charge, but there's enough evidence to show that there may have been a crime of passion or provocation, then we start to say, hey, well, this isn't necessarily temporary insanity. This is a crime of passion. This fits into the world of a manslaughter as opposed to a murder. So that is the angle that we will take it oftentimes.
So walk us through it. Would you just go over his emotional state and try to relate with members of the jury potentially? Since, again, according to police, they're saying that Jonathan Belk, he walked in and found his wife with the victim.
Absolutely. And so, specifically at trials, you're telling a story. You're telling a story. The prosecution has their story they're going to tell. They're going to say, Mr. Belk walked in and found his wife, in bed with another man, and that as a result of seeing that, or as a result of that, that was his motive, although they don't have to prove motive, but that was his motive for killing this individual. Whereas on the defense, we say, yes, again, if the evidence is there, and it's not to say that it always is, but in this case, there may be. Yes, there was an incident that occurred. My client walked in and his wife was having sex, with a young man or with this other individual. And as a result, in response of that, most people would be upset by that. Most people, if they find their spouse in bed with somebody else, would have an extreme emotional reaction to that. And it just so happened that this individual responded emotionally by doing what he allegedly did, which was, I believe, stabbing the individual and also his wife at the same time.
Yeah, I was just about to get into that. Police say that Mr. Belk, he stabbed both the wife and the teenager, and unfortunately stabbed the teenager to death. Does his reaction of, just stabbing suggest a deeper history of emotional or maybe even psychological issues?
It's really hard to tell, and that'll be something that will be explored by the defense when they talk to their client to really get to the history of, if there's any prior domestic violence history, any prior mental health history or diagnosis. That's a conversation that the defense will have with that client. I don't think it's necessarily indicative of a prior history, just because we often do know that sometimes people may react and respond in a way that they may not normally do, because of this type of event, which is significant. And that's not to excuse or justify, but it is a significant event that someone may act out of the ordinary and respond with.
Now let's switch to how the prosecution may handle this case. Given that the victim was allegedly in an intimate situation with the wife, how does that fact play into the prosecution's argument about potential motive?
One of the things the prosecutor is going to do is they're going to attempt to show that Mr. Belk killed this individual because the individual was having sexual intercourse with the wife. And again, the prosecution does not have to prove motive in order for there to be a finding of guilt beyond a reasonable doubt, but they can show it throughout their trial. The jury will hear, well, the motive for committing this crime or this alleged crime is because he found this young man and his wife in an intimate relationship. So it does go to show that there was a motive behind the act, although the prosecution does not need to prove that.
How might the presence of violent intent in a crime of passion, such as stabbing, shift the prosecution's focus in the trial?
So it depends on what the individual was specifically charged with. So what Mr. Belk was specifically charged with. We know that he was charged with a number of homicide charges. With regard to those charges, what are the legal definitions for example, murder in the first degree, murder in the second degree, manslaughter in the first degree? There are specific legal definitions for those things. If intent is one of the part of the legal definition or the culpable mental state for that offense, then I expect that the prosecution is going to argue that he intentionally committed this act, and that although it may have been a quick reaction, say for example it's 5 minutes, and we don't know that at this point, but that 5-minute time period was enough to allow Mr. Belk to formulate the intent to kill this individual. For example, if he walks in, sees them, maybe the bedroom's on the first floor, he walks to the kitchen, goes to get a knife, and then comes back. That few minutes that it may have taken him to go do that can show intent at that point. So that I expect is what the prosecution will argue if intent is a component to that definition or to that charge.
And what kind of other evidence will be crucial in proving or even disproving the claim that this was a crime of passion versus premeditated murder? Like, obviously, we're waiting on more information to come out right now, but if potentially there were text messages or something in the wife's phone that he may have seen, would police or, investigators be trying to find that out right now?
Absolutely. One of the most important things is that the wife was there. She did survive. It is very possible that he may be charged with crimes against the wife, such as assault. We don't know that as of yet. But not only that, but there may come a time where investigators will interview the wife to find out, what she knew, what she saw. She is a witness. Now, whether or not she would ultimately be able to testify is another question. But they will have those conversations with her about what occurred in that bedroom, if at all possible. Not only that, but they'll be looking at text messages, if there's Ring cameras on the house, seeing, what time Mr. Belk got home, what time, he called 911. All of those things are key pieces of evidence that the prosecution and the investigators will use to piece together really what happened.
Okay, so could the relationship between the victim and the wife affect the way the jury views the emotional state of Jonathan Belk, who is accused of the crime, especially given the fact that the deceased victim had just turned 18 years old only a couple of days before?
Well, we don't know if Mr. Belk knew the age of the individual, so that's the first things first. And there's no evidence to indicate that he did as of yet. And there could be later, but we don't know that as of yet. Not only that, but juries are very interesting. Everybody's bringing their outside experiences. So it would not surprise me if the jury is taking into consideration or would ultimately take into consideration the victim's relationship with the wife and the age factor to that. Now, whether or not, Mr. Belk knew the age of the individual is in question. We do know that the wife, I believe, was 31 years old. And this individual had just turned 18 at the time. Now, 18 is the age of consent in the state of Tennessee. So, two consenting adults engaged in sexual intercourse. Whether or not the jury will look at that age gap in reference to Mr. Belk's mental state will be a question. And it's also how the evidence unfolds at trial. Again, did he know it? Did he not know it? Had he had any inkling that, she had been cheating or anything like that, prior to this? Or did he know that there was an affair going on between the two prior to this? All of those things will factor in, but those are things that will come out at trial as it unfolds.
How do juries typically react when they learn about potential infidelity or betrayal within the relationship of the accused? Does it sway their opinion on the defendant's intent at all?
It depends. So most of our legal responses are it depends. So with respect to that, a couple things. I think when the jury hears, if it makes it to a trial, that this individual, was engaged in an extramarital affair, most of us, fortunately or unfortunately, have had that experience to some extent. So I think jurors would reflect on the possibility of that previously happening to them or currently happening to them, or also just being familiar with, the things that go on in society and infidelity and things of that nature. So they may take that experience and formulate their own thoughts and opinions. But one of the things that's going to happen is as the judge charges the jury before they are to deliberate, he will instruct them that, sympathy cannot enter their deliberation. So they can't, make a certain finding because they feel bad for the defendant or they feel bad, for this whole situation. They have to make the decision based on the facts that are in evidence. They have to make the decision based on the law as the judge reads them the law. And then they ultimately deliberate and return a verdict. So they have to be factually based, non-emotional, and make a decision in accordance with law.
Now, the wife, Jada, is a victim herself. Police say that she was also stabbed by Jonathan Belk. But could she potentially face any charges herself? I mean, the victim, Jimmy, who was found in bed with her, had just turned 18 just a few days before the incident. If during the investigation it is revealed that she had a sexual relationship with the victim while he was still a minor, could she face any legal consequences?
My guess is going to be no. And the reason that I say that is because when there's a sexual offense against a minor, oftentimes the minor will be required to testify. And unfortunately, this young man is no longer with us. And so he will not have the ability to testify as to whether or not, she had intercourse with him prior to him turning 18. And of course, you'd argue the facts. Hey, maybe there was a text message or video or photos prior to that, but at this point in time, he essentially would be necessary as a witness, and unfortunately, he's not able to do that or testify to that.
And so hypothetically, even if they do have text messages that explicitly prove this hypothetical situation that I'm explaining right now, she still couldn't be charged.
That is correct. And again, every state is different, but in the state of New York, for example, where we're located, the witness, this individual who was sexually assaulted by this defendant is going to have to talk about what happened. They're going to have to talk about, at age such and such, this person did X, Y, and Z to me. And if the case makes it to trial, that individual will be required, or that child would be required, to come in and testify on the stand to the facts in order for the jury or for the judge to find the defendant guilty. And so in this case, I would assume that Tennessee law, and I'm not all that familiar with it, if it is very similar to New York law, because the individual can no longer be a witness, and there are rules if the witness is unavailable, it's going to be a serious and significant question on if they can even charge her.
Could the parents of the deceased teen pursue legal action not only against Jonathan Belk for the stabbing, the alleged stabbing, but also against Jada for her involvement in the situation, given the nature of her relationship with the victim and potential liability in the events leading up to his death?
Absolutely. I do expect that the family would likely explore those options, maybe some sort of wrongful death suit or something of that nature. And this relationship with the wife, that was a significant and contributing factor to the death of this young man. So I would not be surprised if the family sought civil action against them, both as husband and wife, if they're still married or going to be married. And certainly the relationship between the wife and this young man is essentially the catalyst for this occurring.
If the defendant allegedly stuffed the body in a trash can after the crime, how does this influence the legal case? Because according to police reports, that's where they're saying that they found the victim's body.
It's not necessarily going to impact it one way or another with respect to guilt or innocence. I believe that there is a 911 call that was made by Mr. Belk saying, hey, law enforcement, I just did X, Y, and Z. I put him in the trash. I'm trying to work on my marriage, things like that. So there's not going to really be a question as to whether or not Mr. Belk was the individual that had done this. And the question is more so going to be and hone in on crime of passion. The fact that he put him in a container or garbage tote after this doesn't really make the fact more true or not true one way or another. But again, it depends on how the jury is going to view it. Some may view it as you just discarded his body, like he was trash. Others may view it as he may have still been under this, passionate moment, didn't know what to do. So he did what probably just made sense to him, which was throw him in the trash. Honestly, it depends. But it wouldn't make it for certain that he did or did not. It's not going to change, that fact, allegedly, or alleged fact.
Could that emotional turmoil, though, that, Jonathan Belk may have felt in discovering his wife with another man impact how the case is argued, even if it's not an accepted legal defense?
Absolutely. Absolutely. I expect that the defense is going to argue that, and again, if the evidence is there. So if we have, video footage or ring camera footage that shows this young man and the wife, in the house, and Mr. Belk coming home, and we can hear, a fight or an altercation take place, and some people have cameras in the house, so maybe, that could come into play here if it does. But all of those things are going to factor in. And what the defense is going to do is they're going to paint the picture that, again, this is a man who was just coming home like he would normally, or came home unexpectedly and found his wife in bed with another man. And the emotional reaction to seeing something like that when you've given your life and made a commitment to somebody for life is so just detrimental. It's such a tragedy in the mind of Mr. Belk that he didn't know, what to do. He wasn't thinking at all. His emotions took over and this incident occurred. And so his mental state with regard to that is going to play significantly on how the defense is going to attack this. Again, in Tennessee, if intent is a culpable mental state, then that crime of passion and provocation will negate that mental state on a homicide, and maybe there will be a finding of manslaughter, but that's what the defense is going to more than likely do.
And I was just about to ask, how often is it that these crimes of passions get pleaded down, even if it does result in an unfortunate death?
It happens quite often. What'll often happen is, say, for example, the state will charge murder, or they may charge whatever they ultimately decide to charge. Throughout the discovery process and the negotiation period between the attorneys, and there's conferences and things of that nature, Oftentimes the DA's offices will come with some sort of plea offer that we discuss with our clients. It's not to say that we have to push our clients into accepting it, but our legal obligation is to discuss that with them. And a lot of times with cases that involve murders, homicides, and even sexual assaults, they do plead out. One of the things is you don't really want to re-victimize certain people. Sometimes, and some judges, and I do not agree with this at all, they add a trial tax. They say, well, if you accept the government's plea offer, this will be the sentence that you will get. If you go to trial and you're found guilty, I'm going to give you a significant more amount of time than you would get in this plea offer. So it forces the defense to consider the offer. If the evidence is favorable to the prosecution, then we start to say, hey, what do you think about this? And is this the best course of action to save some time in incarceration and ultimately to save your life?
Great. Well, this is definitely something that we will be watching closely. Thank you so much, Safa, for joining me today.
Thank you for having me.
Belk was taken into custody and faces criminal homicide charges. For Law and Crime, I'm Kennedi Walker.